Hello, this is Sally Annero from Taylor Wessing. Welcome to our webinar. Today's webinar is part of our webinar program where we bring you our expertise and views on topical data protection issues. Our regular attendees will be very familiar with our previous topics, which have covered issues such as managing cybersecurity risks, mobile apps and privacy, data transfers, use of CCTV, and of course the long-awaited EU data protection regulation, among many other subjects. Recordings of those webinars are still available if you've missed them and still wish to engage on those topics. Today, we're going to be looking at the topic of connected data. For those of you who are new to Taylor Wessing or new to our webinar program, welcome. As you'll see from the slide, Taylor Wessing is a leading international law firm. We act for a range of leading clients in local and international markets, providing a full-service law firm offering from our office footprint that spans across Northern, Central and Eastern Europe, Middle East and Asia. We've listed more details about the firm on the slide deck for your reference. Today's webinar is brought to you by Taylor Wessing's International Data Protection Practice. Our team advises on all aspects of data protection and information law from our office footprint. We are a global 22 partner-driven team, and we're also complemented today by our international network of data privacy law specialists. At Taylor Wessing, we have a dedicated microsite specifically for all things data protection, our global data hub. From this site, you'll be able to access news, weekly updates, a monthly mail shot if you register. Typical issues include looking at things that are raising concern, privacy challenges. You can also access our archive webinars and learn about our events around the world, as well as our forthcoming and archived webinars. Also, we feature our risk maps. These are an at-a-glance view of the data protection issues with interactive features for different countries, together with a growing number of country pages for international coverage. As I said, my name is Sally Annero and I'm a senior member of the data protection practice. And today we also have several members of the data protection team and also wider colleagues who are going to be presenting on the range of issues that are covered by this connected data topic. Their profile information is on the following slides for your information. So, as I said, today we're looking at connected data. With more and more computers and devices of all kinds that are connecting to the internet, there's the potential for devices to work together in ways that benefit us or may make our busy lives easier to manage. I'm personally looking forward to the carpet with inbuilt sensors that tells my vacuum cleaner when to hoover. Yet the inevitable consequence of these advances is the collection of greater data on both the devices and the users that sit behind them. To introduce this topic, Debbie Hayward will be looking at the facts behind this intriguing area, and she'll be considering the privacy challenges posed by this Internet of Things. We also have issues around ownership of data, and these are going to be coming increasingly to the fore, and Adam Rendell will be considering who might own the data generated by this Internet of Things. I'll be looking at the data protection issues associated with the emergence of device fingerprinting techniques that can enable cross-device tracking, and also be looking at the response that the EU data protection regulators have produced to the use of this technology. And then my colleague Caroline Arani will be looking at the views of the Article 29 Working Party and the FTC on how privacy and security relating to the Internet of Things should be handled. Following that, we'll be presenting a few polling questions, as we do typically, and then we'll share in aggregated form the collected views of the audience on those questions. So, without further ado, I will pass over to my colleague, Debbie Hayward.
Thank you, Sally. I'm just going to start with a brief run-through of the ways in which data is being used across the Internet of Things and highlighting some of the privacy issues that involve. Current estimates suggest around 2.5 exabytes of usable data per day are being generated, and an exabyte is 1 billion gigabytes. And that amount is only going to continue to grow, fed not least by the estimated 25 billion connected devices which will exist by 2018, according to Gartner. Kevin Ashton, who coined the phrase Internet of Things, has even predicted that we will start measuring data in zettabytes at some point during 2015. There are a number of sectors which are either already making the most of connected data or are planning to do so in the very near future, not least of which is government. A study carried out by SAS and the UK think tank, the Centre of Economics and Business Research, suggests that the UK government could use big data to save £2 billion in fraud detection and £3.6 billion through better rationalisation and management of processes. Some of this will be achieved through data collected by connected devices, but at a more basic level, it's simply a question of efficient data sharing. In terms of connected devices, smart cities and smart transport are massive growth areas. By 2020, it's predicted that 60% of connected devices will be devoted to monitoring or delivering energy and infrastructure, and the Internet of Things will be used in all areas of infrastructure, from smart roads, which use technology to regulate traffic flow, smart parking systems, which will get all the traffic looking for somewhere to park off the roads quickly, to deployment of healthcare and emergency services. The transport operating in this environment will also become much smarter, and driverless cars are the next big thing. Connected home technology is another of the fastest growing areas of the Internet of Things, and wearable technology, while not always as fashionable as we may want, also has enormous potential. Once manufacturers succeed in marrying usefulness with sartorial good taste at a reasonable price, wearables will really take off. In retail, beacon technology and RFID are becoming increasingly widely used with connected data, enhancing consumer experience and facilitating sales. The use of near-field technology devices in payment processing is making contactless payments increasingly popular, and Google and Apple are leading the way in virtual wallets. One of the most exciting areas is the healthcare sector, although this is also the area which causes perhaps the greatest privacy concerns. From apps which tell you how many calories you're burning to remote patient monitoring and medication management, the Internet of Things is revolutionizing healthcare. The data collected from all these parts of our lives is likely to be of huge interest to insurers who will be looking to exploit connected data. By harnessing live data from smart homes, insurers will be able to provide more tailored offerings and make more effective risk analyses. This applies equally to car insurance and potentially to health insurance if data protection obstacles can be overcome. Governments and regulators are furiously trying to cope with the challenges of the smart world, to assess the threats and opportunities in areas like competition, innovation and privacy provided by connected data. In February 2015 alone, the Competition and Markets Authority put out a call for information on the way in which businesses use consumer data, and the Treasury launched a consultation on use of data sharing and open data in banking. Regulators are keen not to stifle innovation, but also want to make sure that individuals are protected. And this is because the many advantages of a connected world also give rise to some hair-raising Big Brother possibilities. A world in which your concentration levels at work are monitored with reminders being sent to you to eat a banana when your energy level drops is around the corner. What becomes of data generated, collected or processed by the Internet of Things is clearly an important question for all involved in the development, manufacture, application and use of related technologies. If this area grows as predicted, then more things and more types of things will be sharing more comprehensive personal data. In a vision of the future where everything is connected, personal data will be collected from a multitude of devices, such as an individual's phone, laptop, tablet, car, fridge, bed, contact lenses, watch, t-shirt, fitness band, home lighting system, and even a microchip under the skin. For instance, always-on sensors inside somebody's body might automatically transmit health information to remote servers, which is then analysed by the technology vendor, stored in the cloud, and potentially shared with third parties. Although such activity might benefit all concerned, it's likely to become increasingly difficult for individuals to keep track of and control what data is shared when and with whom and where it's stored. It's not just data protection which is a concern, but also the wider security issues. There are already examples of people connecting the inside of their body to the internet in biohacking experiments. It might be possible for criminals to hack into your house systems, to work out when you are away or asleep, or to disable the alarm, or for someone with a grudge to drive you mad by hacking into your lighting system and turning the lights off and on all night. Hacked devices could expose a huge amount of intimate and extensive personal data about an individual's health, home and work life. This can and does already happen with laptops and smartphones, but the potential scale and intrusiveness of such breaches in a connected future is ringing alarm bells. It would be very difficult, if not impossible, to read all the privacy policies for these devices and give informed consent to the use of their personal data. Privacy concerns are focused on the lack of transparency about data processing, and there have been calls for manufacturers to be upfront about who will have access to the data and for what purpose. Under a European data protection law, individuals must be given clear and transparent information about what data is collected about them and how it will be used, in addition to rights to manage their personal data, for example, by requesting that inaccurate data is corrected. The Internet of Things may make these rights increasingly difficult to exercise in practice. European law also requires the collection of data to be limited to what is needed for the primary purpose of the technology, the so-called data minimization principle. However, this concept does not sit comfortably with the big data trend of aggregating and crunching pools of data for new applications. Many consumers are prepared to accept that to reap the benefits of the connected world, they have to effectively trade their data and lose some control over it. However, for others, the benefits of connected devices do not yet outweigh privacy concerns. To address these concerns and data compliance issues, manufacturers need to address privacy and security issues and legislative requirements at the design stage and not as an afterthought. And in the EU, at least, will need to develop technological solutions to empower individuals to track and manage their own data. These are major challenges, but meeting them would help ensure the future of ubiquitous computing and connectivity and open the way to huge growth in connected data. This also throws up the question of what happens to ownership of that data, and I'm going to pass you to Adam, who will talk about this in more detail.
Thank you, Debbie. The basic question, who owns a piece of data, is quite a straightforward one to answer. No one owns, from an intellectual property perspective, no one owns that data. So Sally doesn't own, for example, the data generated by her smart carpet, and I don't own the data around how many calories I burnt in the gym last night, as an example. The only thing that is ownable from an intellectual property perspective is an aggregation or collection of that data, provided there has been relevant investment in carrying out that aggregation or collection. And I'm just going to focus now on what it is to make that investment and who makes it. Why is it important who owns the data? I think there's at least two reasons. Firstly, there's obviously potentially enormous value that can be generated, as Debbie was mentioning, and being able to exploit that value, but also stop others from exploiting that value is clearly very important. The second reason is to make sure you can separate the potential ownership interests of the different players in the data processing chain. Any number of players may be involved in the journey of the data from the user of the smart device through the manufacturer of the hardware, an app developer, a provider of database architecture, and the ultimate sort of repository of that data. Identifying who along that chain owns the aggregation of the data is absolutely crucial. Just to step back and look at the IP perspective, what we're talking about here is database rights, which is an EU-specific right, which is designed to incentivize and protect storage and processing of data. There has to be for these purposes, three criteria to be satisfied for a database right to subsist. Firstly, there has to be a database. A database is a collection of independent data which are arranged in a systematic or methodological way and which are individually accessible. The key point being the data must be collected in an orderly way. If data is being captured and transferred in sort of real time without ever being collected, then there is unlikely to be a database. Secondly, there must be substantial investment in the obtaining, verification or presentation of those data. The key concept here really being obtaining. There has to be some form of investment in seeking out and collecting data and bringing them back into the data. With so much data being captured, as Debbie was saying, the opportunity for having to make a substantial investment in collecting it is obvious. And thirdly, and this is something that occasionally trips up those companies and businesses outside the EEA, there has to be a substantial economic and business connection with an EEA state of the maker. Now, that the maker has to be, for example, incorporated in an EEA state with its central administration or place of business in the EEA. If those three criteria are satisfied, the maker will be the first owner of the database rights. In this situation, in the chain that I identified earlier, identifying who the maker is going to be the most difficult task. Two things to look out for when identifying the maker. Firstly, it's the person who takes the initiative, i.e. whose sort of idea it is, to obtain the contents of the database. And secondly, it's the person who assumes the risk of making the investment in the obtaining of that data. Those two criteria have to be satisfied when identifying the maker. Ultimately, I think it comes down to who is economically and commercially responsible for the data being collected. The entity physically doing the collecting might not be the maker, particularly if they have been brought in to provide a service to someone else. Subcontractors, for example, are explicitly excluded from the definition of maker. It's more likely to be the people towards the top of the chain who are more likely to be the maker, those who are making the commercial decision to collect the data and who are making the investment in carrying it out. Of course, the ownership interests can be allocated in contracts, so where you have different entities in the chain contracting with each other, they can allocate between them who owns the rights, and there can, of course, be joint ownership like any other intellectual property rights. So it's a very important sort of practical point to make sure that when the relevant agreements are being negotiated, that appropriate ownership provisions are put in. Certainly, in my experience, that can be quite a difficult part of the negotiation, where you're attempting to ascribe value to the different inputs that the people are having. But I think that conversation is very much worth having in an early stage in the negotiations, because if not dealt with, and it's left to the general law to allocate ownership, there are likely to be very valuable and big disputes between the different parties, given the value of the data and also given the relative legal complexity of this situation. That's all I was going to say around ownership, and I can hand back to Sally, who's going to talk about device fingerprinting.
Thanks, Adam. So, following on from Debbie's scene setting, explaining the context of the wider Internet of Things, and Adam's comments on the issues around ownership of data, you can see that with the emergence of more and more connected devices, companies have been developing new technologies to identify these different devices and build profiles around their unique attributes and to link them with common users. Some of these techniques and the way they're currently used can give rise to some significant privacy challenges and concerns that are potentially far more complex than even those raised by our traditional understanding of cookies. So it probably is a good idea first to explain what we mean by device fingerprinting. Device fingerprinting is, in essence, a way of capturing and combining a range of information elements for internet-connected devices or applications that people use in order to single out or infer over time those attributes to particular devices or users. So that attribution may only happen after a period of time and a significant amount of data has been collected by which unique comparisons can be made. It can be applied across a wide range of internet-connected devices, such as mobile phones, tablets and apps, as well as domestic and consumer electronics, including smart televisions and smart energy meters, games consoles, or internet-connected radios. This works in part due to the open structure of the communication protocols that the internet itself relies upon, it means that connected devices inevitably are transmitting or exposing certain information elements about themselves when online. These bits of information may not in themselves identify the device or its user, but when they're put together with other information about the device, it means that a unique set of characteristics for the device, or a fingerprint, as you might call it, can typically be established, which enables the device and potentially its user to be distinguished from others. So what type of information are we talking about here? Well, there are different types of device traces that could effectively be used to build a fingerprint. For example, this might include HTTP header information, or the device clock, or plug-in software, the identity of the software and the version details, as well as characteristics like the particular screen size that's presented through the browser, and the color depth or system font variables, among many others. Fingerprinting techniques vary. They can include, for example, using JavaScript to identify plugins and fonts and logging these characteristics. In the case of canvas fingerprinting, the device browser is prompted to generate an invisible text or graphic file that is converted into a digital token that stores and then reveals variations in the graphics processing unit of the device. Once a device can be uniquely recognized using a combination of these and other elements, then it's possible for content, services, and in particular advertising to be tailored to that device in the same way as is already possible through cookie technology, but in this case across all devices and applications, not just those that support cookies. However, as it currently stands, fingerprinting is far less transparent and in some cases practically invisible to device users. It can also be more difficult to block. In particular, connected device users do not currently have access to the range of browser tools or provider tools that flag when cookies are used, when fingerprinting is used, and are unlikely at present to know that fingerprinting is being carried out. There's also no clear and simple way to prevent the collection of this information or to reset a device that's universal in order to change the device information elements that are being made available. It may be possible to remove JavaScript to prevent fingerprinting that uses JavaScript, but that's not really a practical solution here, given the importance of JavaScript for normal functioning of most devices. Canvas fingerprinting, on the other hand, can be blocked by downloading scripts that blocks add-ons to the device browser, but many people will not be sufficiently aware or technologically minded at present to know how to control or use those tools. Some have speculated that the growth of fingerprinting has not only been due to the fact that or perhaps has in fact been due to the fact that it can at present be used covertly across a range of devices. There's also perhaps an incorrect assumption by some users of the technology that it falls outside of the scope of the notice and consent rules relevant to cookies within the EU Privacy Directive. This assumption is one that the group that represents the data protection authorities of each of the EU member states, the Article 29 Working Party, have been very prompt to correct with an opinion that they published on 25th of November last year on the application of the e-Privacy Directive to device fingerprinting. The Working Party opinion makes clear from the outset that device fingerprinting presents serious data protection concerns for individuals. The Working Party points to a range of different software platforms and APIs that offer up access to the different information elements of a device, and they flag the inherently covert nature of this information collection as it currently stands by content providers and third parties, who may be contributing site content and and in communication with the user's device. The focus of the opinion is on the application of Article 5.3 of the e-Privacy Directive. Article 5.3 isn't concerned with whether the information at issue is the user's personal data. Rather, it treats both personal data and non-personal data equally. Of course, where personal data is processed, then the General Data Protection Directive must also be complied with. Although Article 5.3 of the e-Privacy Directive may be thought of as simply setting down rules for the use of cookies, it's in fact technologically neutral. Article 5.3 makes clear that the requirement to give clear and comprehensive information about the purposes of processing and to obtain the consent of the subscriber or user applies to any storing of information or the gaining of access to information already stored in the terminal equipment of a subscriber or user. This means it doesn't apply exclusively to the use of cookies, but can be applied to other technologies that store or gain access to device information. It's important to understand that this requirement applies to storing or accessing of information so that fingerprinting is caught, even though certain information elements are not stored. Access to read-only information in the device will also be covered and require user notice and consent. So is any fingerprinting exempt? Well, there are limited exemptions from the requirement at Article 5.3 for notice consent, where the technical storage or access is only for the purpose of transmitting a communication over an electronic communications network, or the storage or access is strictly necessary to provide an information service explicitly requested by the subscriber or user of the service, the necessity exemption. The opinion recognises that these exemptions can still also be relevant for scenarios that involve fingerprinting. For example, perhaps where certain information elements of the user's device may need to be transmitted to enable the proper functioning of a communications network. For example, when managing the connection between wireless devices and a wireless network in order to maintain connections or to route data packets. Or where certain user-centric features are only used to enhance the security of a service requested by the user, such as identifying repeated failed login attempts, which would fall under the strict necessity exemption. Or perhaps where the information elements are only used to adapt the content requested to the user's device, e.g. compressing the content so it appears on a smaller device screen, again under the strict necessity exemption. However, access to or storage of device information in connection with other uses, such as for analytics purposes, for online behavioural analysis, or to control a user's access to a service to a number of specific devices wouldn't be exempt. So the e-privacy directive doesn't offer a get-out for fingerprinting. Those using fingerprinting techniques that are not exempt must still ensure that those uses are transparent with connected device users and collect the user's consent before creating the fingerprint. Businesses are already working within industry bodies such as the Network Advertising Initiative and the Digital Advertising Alliance in the States to ensure choice tools are equally effective in this area. But from an EU standpoint, clear notice and user consent will be necessary to ensure processing is both transparent and lawful. It will be interesting to follow the technology and the legal developments around this to see if industry and or regulators will be acting first to ensure users get more visibility around this technique and that the tools to manage users' privacy proactively where fingerprinting is involved are implemented. And now I'll pass on to my colleague Coraline to discuss the wider issues connected to security of data and handling of data within the Internet of Things.
Hi, my name is Coraline, and today I will focus on the Article 29 Working Party opinion on the application of privacy principles to the Internet of Things. In October 2014, Europe's Article 29 Working Party issued an opinion on the recent developments on the Internet of Things. The Article 29 Working Party is made up of European data protection regulators and is an advisory body that issues non-binding guidance on issues to do with privacy. The opinion focused on three types of Internet of Things devices: wearable technology, quantified self, and home automation. Wearable technology are things like clothes, watches, and contact lenses that have sensors, microphones, and cameras embedded in them that can record, monitor, and communicate data to device manufacturers and third parties. Quantified self are things like pedometers and sleep monitors that monitor individuals and their habits. And home automation or domotics are connected household devices like smart fridges, smart lighting, and smart security systems. In exploring the issues, the Working Party identified a few issues as being the primary privacy concerns arising from the Internet of Things. Firstly, the lack of control and information asymmetry. The communication between individuals, devices, and back-end systems results in the generation, storage, and sharing of certain Internet of Things push data over which the end user has no control. Secondly, the Working Party identified the issue of low-quality consent as being one of the concerning areas. Many of the IoT devices do not contain an obvious point at which the end user can give consent, like a screen or a keyboard. And even more difficult, many IoT-related services do not give any alternatives to the end user's personal data being created, stored, or shared. In these situations, there must be new ways of obtaining a valid consent from the end user. Examples are privacy proxies or sticky policies, which stay with the data regardless of which party has access to it. These are new initiatives that are currently being discussed amongst regulators. Thirdly, the issue is extrapolation of inferences from data and repurposing of original processing. The disclosure of raw data to third parties and the regeneration of data for new purposes can easily go beyond the purposes for which the data was originally collected from the end user. Fourthly, intrusive identification of behavior patterns and end-user profiling is a problem. Certain private behaviors and habits become unwantedly identifiable through the use of IoT, and the data subjects may not necessarily approve of these profiles being created about them, or in fact these profiles may be completely untrue about them. Fifth is the issue of limitations on the possibility of remaining anonymous whilst using services. Wearing IoT objects that are close to the data subjects results in a range of identifiers being available, for example, MAC addresses, with the re-identification of anonymized data also being an issue. And last but not least, there are so many security risks. Low-quality security in IoT devices can make the data vulnerable to being attacked at various points, including the communications link and storage infrastructure levels. The Working Party then looked at how existing and future data protection laws should apply to the world of the IoT. Whilst the opinion is based on the current Data Protection Directive, many of the legal solutions and recommendations are taken from the concepts proposed in the draft EC Data Protection Regulations. For example, the use of privacy impact statements, privacy and security by design, or even privacy proxies and sticky policies. The opinion establishes that European data protection law applies even if the data controller is outside of the European Union, provided that the equipment or device has been used within the European Union. The opinion defines objects very broadly to mean all objects that are used to collect and further process the individual's data in the context of the provision of services in the IoT. Further, the Working Party suggests that end users must be given access to their data collected by the IoT devices in order to enable them to switch providers. Such portability rights should be complemented by data interoperability standards. Data controllers should also give end users the right to disconnect their devices. The Working Party stresses the application of Article 5.3 of the e-Privacy Directive to situations where an IoT stakeholder stores or gains access to the information already stored on an IoT device, as that device will qualify it as terminal equipment for the purposes of Article 5.3 of the Directive. This means that the stakeholder must gain the user's consent to such storage or access except where it satisfies the strictly necessary requirement that the operation is necessary to perform the service requested by the user. This almost begs consent in almost all instances for the use of their information on IoT devices, and it probably presents quite a problem for device manufacturers and producers. The Working Party identifies three legal bases for justifying processing of data. Consent, where processing is necessary for the performance of a contract to which the data subject is a party, and where the processing is necessary for the purposes of legitimate interests of the data controller, except where overridden by the interests or fundamental rights of the data subject. The opinion cites the Google Spain judgment to underline that economic interests will not, by themselves, satisfy the legitimate interest requirement. Data controllers are reminded to comply with the data protection principles. Notably, the data should be processed fairly and lawfully. The purpose limitation and data minimization principles, that the data be kept for no longer than strictly necessary, and that special requirements for the processing of sensitive data be complied with. In addition, data controllers must communicate information about themselves and the existence of data subject rights of access in a clear and comprehensible manner, must implement the appropriate security measures. The working party is particularly concerned that IoT devices are difficult to secure for both business and technical reasons and are particularly vulnerable to attack. Working Party is keen to underline that any personal data which is processed with a view to anonymization is still personal data subject to data protection law until such time as it is genuinely anonymized. Pseudonymous data is still personal data. Interestingly, and I think the most novel part of the opinion, is that the Working Party sets out a number of very practical compliance tips for a variety of stakeholders across the IoT ecosystem. Most importantly, there are a set of recommendations that are common to all stakeholders, and those are the ones that I'll list out today. Firstly, all stakeholders should undertake a privacy impact statement before IoT launch. All stakeholders should delete raw data as soon as the relevant data has been extracted. Stakeholders should follow privacy by design and privacy by default. Therefore, bake privacy into the product before releasing the product rather than thinking about it after it's been launched. Stakeholders should ensure the user is in control, i.e. the user can always change their preferences about their consent or how data can be used. Stakeholders should make the right to refuse or withdraw consent as user-friendly as possible without any technical hindrances in the device. And lastly, all stakeholders should ensure the devices and applications are designed to inform the user and non-user data subject. It will be interesting to see how data regulators around the member states of Europe will react or how they will implement the Working Party opinion. As you know, this is a non-binding guidance. I think we can be certain that it's unlikely that the whole thing will be adopted by all data regulators. Certain data regulators may be stricter than others, for example in Germany and France, whereas I think the UK regulator, we can hope, would take a more pragmatic approach to adopting these recommendations. We would certainly hope that they balance the interests of protecting the individual's privacy and the ability to innovate in this space when they regulate for privacy in the IoT world.
Thank you, Caroline. So we're going to be moving on to some polling questions. And when you respond to the polling questions, can you please make sure that you click the submit button after you make your particular choice? But let's just quickly run through each of these polling questions. Firstly, can a balance be found for big data and data protection? Yes or no? 2, do you use a structured privacy impact assessment process before you introduce new technology or innovations? Sometimes yes or never. 3, are you already using device fingerprinting technologies? Yes, no, unsure. Whilst those responses are coming through, we've had a couple of questions in. One particular which was interesting, which is to what extent do we think that the proposed changes to the EU data protection regulation are going to be particularly relevant to the Internet of Things? And I think this is probably a webinar in itself. The data protection regulation will certainly have potentially far wider reaching impact on the Internet of Things. For example, there'll be stronger definition of personal data. There is wider reach of the law, so data and services that are offered outside of the EU may still potentially be within the reach of EU regulators. The definition of personal data will include pseudonymous data, for example, so certainly identifiers that may not in themselves directly identify an individual are likely to come within scope. And then, of course, there'll be much more in the way of enhanced rights for individuals, rights of access, right to challenge the processing of their information, formalised obligations to conduct privacy impact assessments, and to incorporate privacy by design and default into connected device technologies. There's likely to be a stronger definition of consent, which will be interesting for individuals who are providing and sharing data with the providers of connected devices. And then in relation to things like security, the extension of the law to processors, who will now also be on the hook for the data that they host on behalf of clients and individuals, and formalised breach reporting obligations will bring the importance of securing data to the forefront of data controllers and data processors considerations. And then, of course, this is going to be backed up by the potential for far greater fines of between 2 to 5% of global annual turnover. So there are certainly many compliance challenges for organisations that are either providing connected devices and collecting data from connected devices that will be presented by the data protection regulation if and when it is finalised and coming into law. So we've got the feedback from the attendees on the polling questions. And in relation to the first question, can a balance be found for big data and data protection? Yes, is the overwhelming response to that. 86% of respondents believe that a balance can be found for big data and data protection, and only 14% think that the challenges are overwhelm the possibility of finding a balance in this area. Second question, do you use a structured privacy impact assessment before you introduce innovation and technology? 18% said yes, 61% said sometimes, and 14% said never. Now that's quite an interesting response, because we have asked this question on previous occasions where we have looked at the role of assessing and formalising your risk assessments for new and novel processing techniques, and that is certainly an increase in terms of the number of respondents who are now integrating privacy and impact assessment processes into their compliance processes. So that's an interesting increase in use of PIAs. Thirdly, are you already using device fingerprinting technologies? Yes, 11%. The majority, however, are saying no. 64% saying they don't use fingerprinting technologies, and 21% are unsure. I think, as I say, we are perhaps talking about a technology or a technique that is only perhaps recently starting to gain the attention and the concern and interest of both regulators and industry alike, and I think we'll be certainly reading a lot more about that technology in the coming months and years. So, on that point, I just wanted to let you know that our next webinar is going to be an international update that's going to include a special feature on the Russian data localization legal developments that are causing quite a lot of controversy around the requirements for local server storage in relation to the data of Russian citizens. And we're going to be announcing a date for this webinar quite shortly. So with that, I'd like to thank you for joining us today, and for more here at Taylor Wessing, goodbye.